Okay, let's unpack this. AI is changing everything around us, like incredibly fast.
It really is.
And as it spreads into, well, everywhere, governments are kind of scrambling to set some rules, right?
Trying to catch up, definitely.
So today we're doing a deep dive into how two big players on opposite sides of the Atlantic are trying to do just that, setting ground rules.
Yeah, and we're going to explore how the European Union is laying down binding laws with its AI Act,
Okay.
while the U.S. is taking more of a guiding approach with its blueprint for an AI Bill of Rights. So you'll get a really clear picture of their quite distinct approaches.
Distinct is definitely the word. So our mission today is to make sense of these two key documents, the EU AI Act,
Right.
which is Europe's big move to regulate AI, and the U.S. blueprint for an AI Bill of Rights.
Two very different beasts.
Exactly. Think of them as, I don't know, twin pillars trying to bring some order to this exciting but sometimes kind of chaotic world of AI. It feels like a really crucial conversation.
It absolutely is. For anyone building AI, using it, or just, bumping into it daily.
So let's start with the basics. What actually are these documents?
Okay, so the EU AI Act, first thing to know, this isn't just a suggestion. It's a full-on comprehensive regulation.
Right. Actual law.
Actual law.
Yeah.
Legally binding across all 27 EU member states. And its core idea is this risk-based framework.
Risk-based.
Yeah, basically looking at AI systems and figuring out how risky they are.
Yeah.
Aiming to protect fundamental rights, public interests,
Yeah.
making sure AI is used responsibly.
Okay.
And what's really interesting is its reach. It's extraterritorial,
Clean.
meaning it can apply even if the company making the AI isn't in the EU. If their AI is put on the EU market or if its output is used in the EU, the act can apply.
Wow. Okay. That's broad.
It is. And it's rolling out now, most big parts starting around August 2026, but some bans actually kicked in early 2025.
And the U.S. side. The blueprint.
Very different animal, like I said. It's non-binding.
Non-line. So, guidelines.
Exactly. A set of 5 key principles with some practical advice. It's meant as a policy toolkit for U.S. agencies, for developers, to kind of inform how they design AI or make policy, especially where maybe existing laws don't quite cover AI's challenges.
Okay.
Oh, and one important point. It specifically carves out national security and
Yeah.
defense stuff. So those are subject to different safeguards.
Right. Okay. So that's clear then. One is strict enforceable law in Europe.
Yep.
The other is a guiding set of principles in the U.S. That's a massive difference right out of the
A
gate.
huge difference. Sets up completely different dynamics.
Let's dig into that dynamic. Who actually has to follow these rules and, when do they really bite?
Yeah, the who is critical. The EU AI Act, being law, mandates compliance.
No choice.
No choice. For providers, and remember, that includes companies outside the EU if their AI's output lands in the EU, and also for employers, the ones actually using the AI within the union.
So that example you mentioned earlier, the Indian company with software used in Germany.
Exactly. They're legally bound by the Act. It's not optional.
Yeah.
And there are specific dates for different parts to become enforceable.
Okay. And the U.S.
The blueprint, being non-binding guidance, well, it strongly encourages companies to adopt its principles,
I encourage this.
but doesn't directly compel them legally, not as a standalone thing. It's more about shaping best practices, influencing maybe how existing laws are applied.
Right, so you get that Brussels effect, the EU rules potentially setting a global standard because companies might just comply everywhere to access the EU market.
That's definitely part of the conversation, yeah.
Okay, so that legal difference leads to the philosophy. What's the core thinking behind each approach? Risk versus rights.
That's a great way to put it. The EU AI Act is fundamentally built on that risk-based model we talked about. It puts AI systems into categories. Unacceptable risk, banned outright,
Gone.
gone. High risk, super strict requirements, then limited risk, minimal risk, with fewer obligations that you go down. It's very structured around potential harm.
Proactive, almost.
Very proactive. Now, the U.S. blueprint takes a rights-based model. It outlines 5 fundamental rights that automated systems should protect.
Okay, what are they?
Safe and effective systems, algorithmic discrimination protections, data privacy, notice and explanation, and human alternatives, consideration, and fallback.
So it's focused on the person being affected.
Exactly. These rights apply to basically any automated system that could meaningfully impact your rights, opportunities, or access to things.
So Europe. Assess the danger, regulate the tech. U.S., protect the person's rights, guide the tech.
That's a pretty good summary, yeah.
Yeah.
A fascinating philosophical split.
Can you give us a practical example? How would that play out?
Sure. Think about AI used for, say, patient triage in a hospital.
Okay, high stakes.
Very high stakes.
Yeah.
In the EU, that system would automatically be classed as high risk,
Right.
triggering all those stringent rules, conformity assessments, monitoring the whole package. It's a defined process.
And in the U.S.?
In the U.S., that same system would be looked at through the lens of the safe and effective systems principle.
Okay.
The expectation would be that the developers did rigorous testing beforehand, that they have ways to mitigate risks, all to protect patient rights. Both want safety, but the EU mandates the process, while the U.S. focuses on the outcome of protecting rights.
Got it. Which brings us to enforcement. How do these rules actually get put into practice? What happens if you don't follow them?
Right, the consequences. The EU AI Act is very, very specific about obligations, especially for those high-risk systems.
Like what?
Things like mandatory conformity assessments, basically, proving your AI meets the standards before you can sell it or use it.
Like a safety check.
Exactly. Plus, requirements for quality management systems, tons of technical documentation, and ongoing post-market monitoring after it's launched.
And who checks all this?
National authorities in each EU country, overseen by a new European AI board and a central AI office. And the fines for getting it wrong. They're serious.
That's serious.
Up to 35 million euros, or even 7% of a company's global annual turnover for the worst offenses, like using prohibited AI.
7%. Wow. Okay. That's definitely got teeth.
It really does.
So what about the U.S. blueprint? How does enforcement work there if it's non-binding?
It's a different route. The blueprint doesn't create a new AI police or anything.
Okay.
Instead, it relies on existing laws and the regulators already policing different sectors. Think the FTC, the Federal Trade Commission, or the CFPB, the Consumer Financial Protection Bureau.
Ah, so they'd use their existing powers.
Exactly. The blueprint acts as guidance for them to maybe interpret their existing rules in light of these AI principles.
So, an example.
Okay, say an EU company provides a high-risk AI for managing the power grid. If they mess up, they face direct penalties under the AI Act.
Right.
In the U.S., if a company's AI system isn't safe and effective and causes harm, they might get sued or face action under, say, existing consumer protection laws, but not because they violated the blueprint itself directly.
So, EU, new AI police, new AI rules. US use the existing police, but give them new AI guidelines.
It's a good way to think about it. Fundamentally different strategies.
Okay, let's get concrete.
Yeah.
What kind of AI uses are specifically targeted or even banned? This usually tells you a lot.
Yeah, the EU Act is very explicit here. It outright prohibits certain things.
Like what?
Like social scoring by governments ranking people based on behavior.
Wow.
Also bans AI using subliminal tricks to distort your behavior in harmful ways, or scraping facial images from the internet without targeting to build databases. Those are just flat out banned.
Okay. And the high-risk stuff?
High risk, needing strict compliance, includes AI in hiring, credit scoring, medical devices, law enforcement, managing migration and asylum, and even in administering justice. Really sensitive areas.
Makes sense. And the U.S. blueprint, does it ban anything?
Not in the same explicit way because it's principles-based.
Okay.
It doesn't have a list of banned AI. Instead, it puts heavy emphasis on protecting against algorithmic discrimination in those same kinds of areas: jobs, housing, credit, education.
So, focuses on the harmful outcome.
Exactly. It also says things like continuous surveillance shouldn't be used in schools or workplaces where it limits rights under its data privacy principle. But it's framed as a protection, not an outright ban from the blueprint itself.
So the EU says, don't build this specific harmful thing, while the US says, don't let your tech result in this specific harm.
That's the gist of it, yes. A very different feel.
Okay, what about us? The individuals interacting with this stuff. How do these documents make sure we understand what's going on and have some recourse, transparency, and oversight?
Both frameworks care a lot about this, but again, different approaches. The EU Act mandates transparency for high-risk systems.
Mandates how?
Clear instructions for use, systems that log what they do so you can trace decisions. And crucially, deployers must tell you if you're subject to a high-risk AI system and about your right to an explanation.
So you have to be told.
Yes. And there's a requirement for human oversight for high-risk systems. A human has to be able to step in to override the AI.
Okay, that's significant. What about the U.S. blueprint?
The blueprint has two whole principles dedicated to this: notice and explanation, meaning you should know when AI is used and understand how it affects outcomes.
Uh-huh.
And human alternatives, consideration, and fallback. This one says you should have the right to opt out of AI for a human, especially in important situations, and access human review if something goes wrong.
So the right to talk to a person.
Basically, yes.
Yeah.
The right to not be solely judged by a machine without recourse.
So if a bank's AI denies you a loan?
In the EU, under the Act, they'd have to tell you AI was involved, if high risk, and allow for human review.
Okay.
In the US, existing laws like fair credit reporting already require banks to give reasons for denial. The blueprint reinforces that right, saying complex algorithms don't get a pass on providing an explanation.
That makes sense, building on what's already there. Okay, let's talk cutting edge. Generative AI, ChatGPT, these massive models. How do these frameworks handle those?
Yeah, that's a huge question now. The EU AI Act actually added specific rules for what it calls general-purpose AI models, or GPI models,
GPA.
especially for models deemed to have systemic risks, the really powerful ones.
What do they have to do?
Providers need detailed technical documentation. They have to give info to companies using their model downstream, and importantly, publish a detailed summary of the content used for training.
Training data summary, including copyrighted stuff.
Yes, the Act 2 Act specifically mentions needing to comply with copyright law and be transparent about it. And a model might be tagged as systemic risk based on things like how much computing power was used to train it.
Wow, okay, getting into the weeds there. U.S. approach.
The blueprint, true to form, provides principle-level guidance. It doesn't have specific rules just for generative AI or foundation models.
So how would it apply?
Principles like safe and effective systems or algorithmic discrimination protections would push developers to test these big models for bias, make sure they work reliably, make them explainable. It points towards things like the NIST AI Risk Management Framework for guidance.
So less prescriptive about the model itself, more about the outcomes and testing.
Exactly. The EU is saying, tell us how you built this foundational thing, while the US is saying, make sure the foundational thing behaves itself according to these principles.
Got it. And what about the data itself, the stuff that feeds the AI, data governance testing?
Crucial area. The EU Act demands that high-risk AI systems use training, validation, and testing data that meets quality criteria. It has to be relevant, representative, and checked for biases.
Checked how?
Providers need a whole risk management system across the AI's lifecycle. The Act also encourages things like AI regulatory sandboxes, safe spaces, to test AI under supervision, and even real-world testing, but with strict rules.
Okay. And the U.S. blueprint on data.
It talks a lot about proactive equity assessments during design, using representative data, and doing pre-deployment and ongoing disparity testing to fight discrimination.
Disparity testing.
Yeah, actively looking for biased outcomes. It also pushes for limits on data collection and reuse, especially for sensitive info, under the data privacy principle.
So both are really focused on data quality and bias, just framing it slightly differently.
Absolutely. There's a clear consensus that biased data leads to biased AI, and that's a major risk everyone wants to avoid.
Right. So stepping back, who gets hit hardest by all this? Which sectors? What kinds of companies?
Well, the impact is pretty broad for both. Think finance credit, insurance, healthcare diagnostics devices, education, employment hiring, managing workers,
Yeah.
and the public sector, law enforcement, migration, benefits, justice.
The big, impactful areas.
Exactly. The EU Act also specifically mentions critical infrastructure, like energy grids.
And company size. Does it matter if you're a startup or a giant?
The EU Act technically applies to everyone, big or small, but it does have some provisions to ease the burden on SMEs, like priority access to those sandboxes or simpler requirements sometimes.
Okay.
The U.S. blueprint aims its guidance at governments at all levels to companies of all sizes, but since it's guidance, the practical burden might feel lighter for smaller players compared to the EU's legal mandates.
And that global spillover you mentioned.
Right, the EU Act's extraterritorial reach means companies outside the EU making AI for that market have to comply. That Brussels effect could push global standards towards the EU model, just for simplicity.
Definitely something for global companies to watch. Okay, let's bring it home for our listeners. Practically speaking, what should you know? What are the key takeaways for consumers?
Okay, number one, expect more transparency. You should be informed when you're dealing with an AI, especially for big decisions. The EU mandates this unless it's obvious. The US blueprint strongly pushes for clear notice and explanation.
Know when it's AI. Got it.
Number two, the right to a human. In high-stakes situations, you should increasingly have the option to opt out or ask for human review. That's a core principle in the U.S. blueprint and baked into the EU's human oversight rules for high-risk AI.
Okay, the human fallback.
Third, avenues to appeal. If an AI decision negatively affects you, there should be ways to contest it.
Yeah.
The U.S. blueprint talks about fallback and escalation. The EU Act protects rights like getting an effective remedy bolstered by transparency.
So you can challenge the machine.
You should be able to, yes.
Yeah.
Fourth, privacy. Expect stronger protections for your data, especially sensitive stuff like health info. Both frameworks emphasize limiting data use and fighting bias, with the EU having very specific rules around things like biometric data.
Good. And finally,
Finally, just be aware. Look out for those AI is used to your notices in plain language. That transparency is a cornerstone for both approaches.
excellent takeaways. So if we boil this whole comparison down, really simplify it, it's basically rules as law from Europe
Yep.
versus rights as principles from the United States.
That's it in a nutshell. One's a top-down, proactive legal structure. The other is flexible, rights-focused guidance meant to work with existing laws.
This has been fascinating. It really shows these two huge economic powers taking fundamentally different routes to tackle the same massive challenge, managing AI.
It does.
And the big question hanging in the air is, how will these two approaches coexist or compete globally? Will we see convergence towards one model, maybe driven by that Brussels effect? Or are companies just going to have to navigate two very different worlds for AI development and deployment for the foreseeable future?
That is the billion-dollar question, isn't it? How this plays out globally will shape AI for years to come.
Something for all of us to keep a very close eye on. Thanks so much for breaking that down.
My pleasure.
Yeah.
It's a complex but crucial topic.